Hello, everybody. We're going to get started. I'd like to welcome you to ACS's annual Supreme Court Review. I'm Caroline Fredrickson. I'm the Executive Director of the American Constitution Society for Law and Policy. ACS was founded in 2001 and is one of the nation's leading progressive legal organizations and a rapidly growing network of lawyers, law students, scholars, judges, policymakers, and others who care about our Constitution. So the Supreme Court decided 82 cases during the 2010-2011 term, addressing important questions about class actions, preemption, consumer rights, free speech, immigration, employment, and criminal law. Our panelists have graciously agreed to highlight for you the cases and the trends they think you should pay attention to this term. Perhaps even more graciously, they have agreed to join us for a happy hour immediately following the program at the Laughing Man Tavern, which is nearby at 1306 G Street. So if you want more insights into the Supreme Court terms over a glass of wine, you should join us there. So I do not want to take much time away from this panel of illustrious lawyers. So I just want to say I have the extra special honor of being able to introduce today's moderator, Kathleen Sullivan, who will introduce our 6 panelists. So you have full biographies of all of today's speakers in the handout you received. So I will only briefly touch on Kathleen's background. Kathleen, of course, needs no introduction at all, but that would deny me the honor of being able to introduce her. So I'm going to do it anyway. Kathleen has taught at Harvard and Stanford for 26 years and was dean of Stanford Law School from 1999 to 2004, the first woman dean of any school at Stanford. She edited the leading con law casebook, formerly with the great Gerald Gunther, for 15 years, has published widely on free speech, federalism, separation of powers, and the role of the court, and has chaired the appellate practice at Quinn Emanuel since 2005. She's been a named partner at the firm since 2008, the first named woman partner at an Am Law 100 law firm. She has argued 6 cases in front of the Supreme Court and numerous cases in lower federal courts and the state courts. In other words, she's an exceptional guide for us for today's conversation. So please join me in welcoming Kathleen.
Thank you so much for that very generous introduction. Thank you, ladies and gentlemen, for coming out to the American Constitution Society Supreme Court wrap-up. We have a phenomenal panel to discuss the terms cases, a term that brought together the right to play Mortal Kombat, the ability of Anna Nicole Smith's estate to go to bankruptcy court, and numerous other topics that we'll talk about. We'll talk a little bit about whether this term did or did not confirm the view that the Roberts Court is a pro-business, pro-corporation court. Is that an accurate view or not? So to introduce the panelists, starting immediately to my left, Lucas Gutentag, who was the founding national director of the Immigrants' Rights Project of the American Civil Liberties Union, and has served for 30 years with great distinction as an unfailing advocate for the rights of immigrants in a variety of courts, including the U.S. Supreme Court. He's now resident at Yale as a lecturer and senior fellow. Next to Lucas is Suzette Malveaux. Suzette is a professor at the Catholic University Columbus School of Law in Ohio, where she teaches civil procedure, complex litigation, and civil rights and fair employment law. She's the author of a casebook on class actions and an author of many law review articles that explore the intersection of civil rights and civil procedure law. And you may have seen her as one of the most articulate commentators in a number of forums, including the PBS NewsHour, on issues pertaining to the Supreme Court and other federal legal issues. Next to Suzette, we have Paul Smith at Jenner & Block, extraordinarily distinguished Supreme Court advocate in a variety of cases, including a victory this term, which we'll talk about later, in the Brown versus Entertainment Merchants case. That was the case that declared the right to play Mortal Kombat on a par with Dante's Inferno. And we'll hear from Paul about how he won that. a great appellate practitioner and a great friend to the American Constitution Society, where he's been so active over the years. Next to Paul is Allison Zeev, who is the director of the Public Citizen Litigation Group and runs its Supreme Court Assistance Project, which is a wonderful vehicle for helping people who work on a variety of Supreme Court cases get prepared for their arguments. Her practice focuses on administrative law, access to courts, and government transparency, and she had a lot of cases last term. She was co-counsel in the court in Williamson versus Mazda and Smith versus Bayer, and her office was lead Supreme Court counsel for the plaintiff in AT&T versus Concepcion. Next to Allison is Chris Bartolomucci, who is a partner at Bancroft, and he also is an active Supreme Court practitioner. In the October 2009 term, he argued in South Carolina versus North Carolina on behalf of interveners, and he was also shortlisted as a candidate for the Fourth Circuit, highly rated one. But I think it's a gift to the practicing bar that he's on this side of the bench and still arguing cases from Bancroft. Next to Chris, we have Erica Hashimoto, who is an associate professor at the University of Georgia Law School. She clerked here in DC for Judge Friedman and then for Judge Tatel on the circuit, and then served as an assistant federal public defender. And she has taught at the University of Georgia since 2004. Her scholarship focuses on the Sixth Amendment right to counsel and the right of self-representation, where I think she got a nod on that scholarship from the Supreme Court in a recent argument. So please join me in welcoming the panel. So to start us off, I'd like to turn immediately to Suzette to tell us a little bit about some of the big class action cases this term. Class actions was a theme this term. Just to recall a little bit and put it in context, we've seen that over the last several terms, the Roberts Court has issued a lot of cases in a wide variety of legal areas, including pleading standards, standing rules, private rights of action under federal statutes, in which you might say the Supreme Court has done a lot to limit plaintiffs' easy access to civil litigation through threshold doctrines that make it harder to get going in a case, whether you're to be dismissed on a complaint for failing Iqbal Twombly, or to be denied a private right of action to bring your suit at all, to be required to plead facts with greater particularity. This term, it was Rule 23. Is this a new area where the Supreme Court was making threshold law that makes it harder for plaintiffs to bring, in this case, large-scale class actions in Walmart versus Dukes, or in AT&T versus Concepcion to bring consumer class actions in lieu of arbitration?
Absolutely. I think this term, class actions were really hit hard in the consumer and employment discrimination area because of a confluence of those two major cases, the AT&T Mobility versus Concepcion and the Walmart versus Dukes. And so in consumer and employment area, sort of that critical procedural device, the class action, really took a couple of punches. I would say that it's not dead, but it certainly was injured by the term this year. The first blow was AT&T. And I think the AT&T case makes it easier for companies to basically kill class actions altogether by putting them in an arbitration agreement. And so what's been happening increasingly is companies will have people sign arbitration agreements. Those arbitration agreements force people, if they have a dispute in the future, to have that dispute resolved by an arbitrator as opposed to a judge. And so these are kind of take it or leave it types of deals. You can't really negotiate them. And in some of those arbitration agreements, there is a class action ban. So you're not allowed to go forward and pursue your case, your dispute with other people in a class action. And so the state of California, as well as a number of other states, thought that some of these class action bans were unconscionable, basically because they are acting like exculpatory clauses. They can effectively immunize a company from the state consumer laws by requiring people not to be able to sort of collectively bring their case together, which is a very effective tool. So the court was looking at the question of whether or not the Federal Arbitration Act, in fact, preempted California's unconscionability rule. And the court had determined that, in fact, it was preempted by the Federal Arbitration Act.
This was a conflict preemption ruling, right?
Right.
To interpret state contract law to render unconscionable an arbitration agreement was to foil or create an obstacle to the purposes of the Federal Arbitration Act?
Right, right. So the conservative majority thought that the class action and the arbitration were sort of inconsistent with one another, sort of procedures that wouldn't work well together. And I thought what was interesting about the case is the fact that the conservatives, they sort of took a different position. Normally you would expect the conservative majority to have been talking about federalism and states' rights, and instead it was the dissent that was talking about that, and the conservatives were in fact sort of deferring to a preference for arbitration. So I think as a result of that case, we can expect to see many more companies inserting class action bans in arbitration agreements. The other sort of blow to class actions was the Walmart versus Dukes case. A lot of folks have heard about that, with 1.5 million women across the country challenging pay and promotions, gender discrimination against Walmart. And that was there are two things happening in that case that I thought were significant. First, you had a 5-4 split, with the conservatives raising the bar for class actions and saying that you have to have significant proof of a policy of discrimination in order to meet that commonality standard. Basically, that the plaintiffs had not met that bar, and that in fact there wasn't enough glue to sort of hold the case together as a class action. And so really raised the bar. I think that was devastating for employees who are challenging nationwide systemic discrimination of that magnitude against an employer that large.
So could I just pursue Walmart a little bit with you? The court did split 5-4 on whether a group of women subject to discretionary policies in which supervisors could make decisions one at a time, whether that created enough commonality for a class. But the court was unanimous in holding that the class action here was not properly certified under 23B2 because it involved many individualized back pay claims that ought to have been subject to individualized treatment. Doesn't the 9-0 unanimity on the B2 issue suggest that it's not such a conservative liberal split after all?
You know, it's an interesting. It could look like that. I mean, I think it was an interesting. I was surprised, frankly, by the unanimous conclusion that that back pay wasn't permitted under this type of class action. I was a little surprised in part because, really, if you look at the court's decisions, almost the last 50 years, the courts have been permitting back pay under this particular provision of the rule. Because back pay is so important, it's equitable relief, and it's important to Title VII's remedial scheme, that it was a little surprising to see what I think is really, almost a half century of Title VII jurisprudence being reversed in that manner.
Do you think the biggest impact will be on employment discrimination actions, especially disparate impact actions that will be harder to mount under 23A?
I do think that this case will make it more difficult in employment discrimination cases. Looking at the case, I would sort of be wary to say that across the board, all class actions are going to be
securities,
negative. Right.
Antitrust may be unaffected.
Right. I mean, it really speaks a lot to the back pay question. It really speaks a lot to what does it take to have this common glue for employment discrimination. So it seems. It does really seem tailored to the facts and to employment discrimination cases in general. Okay. So I do think it's going to be much more difficult for people to proceed with this kind of systemic sort of challenge.
Okay. Chris, if I could turn to you, there was another class action case this term, but the plaintiffs did pretty well. The Halliburton case, in which the court declined to require proof of loss causation in a securities class action at the class certification stage. And I wonder if you could tell us about Halliburton and maybe tie it to two other securities law cases this term, Janus and Matrix, and tell us whether there's a trend in the securities cases this term.
Well, this was a pretty big term for the securities law bar. There were 3 decisions, and these are also class action cases. These securities fraud cases are brought as class actions. 2 of the 3 were unanimous, so one was 5-4. In 2 of the 3, the public corporation that was the defendant lost the case. So that's a data point we might talk about in connection with the question whether the Roberts Court is pro-business or not. In the Halliburton case, Erica John Fund versus Halliburton, Halliburton lost. So if you thought the Roberts Court was in the tank for big bad, evil corporations, you'd think they would be in the tank for Halliburton, but they weren't. Actually, this is a very narrow decision. The Fifth Circuit had a unique rule which it had grafted onto the requirements for class action certification. The Fifth Circuit had said that in securities fraud class actions, the plaintiffs had to demonstrate loss causation, which is a required element of a securities fraud claim, in addition to the other requirements for class action status under Rule 23. And in a sort of plain meaning judicial restraint decision, in an opinion by Chief Justice Roberts, the court said, no, the Fifth Circuit rule is wrong. Just all you have to do is meet the requirements of Rule 23, and you can be certified as a class action. So here's a case where a court of appeals had essentially grafted on an additional requirement to make it a little bit tougher for class action plaintiffs, and the court rejected that. The other class action securities fraud case that went in the way of the plaintiffs was called Matrix Initiatives. And this is a case in which the makers of the Zicam cold remedy had been publishing rosy statements about their future at the same time that they were receiving from physicians reports of adverse effects of the use of the drug. And they had been sued in several cases. And the company had not disclosed these facts. And the issue before the court was whether in determining that this was a material misstatement, did the omissions have to be statistically significant? In other words, Matrix said, look, yeah, we heard some adverse reports, there were a few lawsuits, but these weren't statistically significant, so we didn't disclose them. And the court rejected that approach. It rejected the bright line rule of statistical significance, and it reaffirmed the test, which had been one of totality of the circumstances. Now, there's a certain view that totality of the circumstances as a jurisprudential approach is anti-conservative. And you may know there's this famous law review article by Justice Scalia called "The Rule of Law as the Law of Rules," where he strongly argued that the better method, and one more aligned with conservative ideals, is to use bright line rules and to avoid sort of mushy totality of the circumstances tests. But here's a case where the court unanimously embraced the mush and rejected a bright line rule, and did so in favor of the securities fraud plaintiffs and against the public corporation.
And Chris basically said that even unreasonable information or unscientific information, in this case there was a fear that the cold remedy led to a loss of a sense of smell, but there was a big discussion at oral argument about what about a connection of a product to Satanism. And it might have an effect on the stock price, but is that something the company has to disclose? And the answer was basically yes, right? That even unreasonable facts might have an effect on the reasonable investor.
And this also connects to Iqbal and Twombly. The court said, at the pleading stage, as long as you've alleged some facts that are enough to make your claim plausible, that maybe it's plausible that investors might consider this information significant and that you'd discover more information in discovery, that's right, that you have to disclose that information, and we're just going to ask what reasonable investors would consider to be material, and whether you have plausibly alleged that this information was relevant. Just quickly, the last of the three cases was the Janus Capital case, and this case had to do with who could be liable for, under the securities laws, for allegedly making an untrue statement of material facts. And this is a 5-4 decision, and this is kind of a schoolmarm opinion. It's very textualist. Both the majority and the dissent pulled out their dictionaries and parsed the meaning of the phrase, make a statement. The majority opinion written by Justice Thomas said that to make a statement essentially means to state. So under the majority opinion, only the corporate entity that actually published the allegedly misleading statement could be held liable, and the investment advisor that had contributed to the statement could not be. And the court analogized to a speaker and a speechwriter. The court said that a speechwriter doesn't make a statement. It's the speaker who makes the statement and not the speechwriter. Justice Breyer, in his dissent, did not concede the textualist ground. He pulled out his own dictionaries and said, look, to create a statement that's uttered by someone else is also to make a statement. So this is an interesting case where both sides were largely debating on the ground of text, and it comes out 5-4 in this case in favor of the corporate defendant.
So I take it the most important takeaway is that the law clerks can never be liable for the justice's opinions.
Correct.
Allison, if I could turn to you on preemption and just pick up on something Suzette said a moment ago. Suzette said, isn't it unusual that we think of states' rights as a conservative doctrine, hallmark of the 5-4 decisions of the Rehnquist Court, and yet now in preemption cases, in case after case, it's often a 5-4 majority of conservatives, or sometimes a more lopsided one, and the National Chamber of Commerce that's arguing for federal preemption, uniform national law, the power of the federal government to displace state law, including state common law lawsuits. So 3 product liability cases this term, the Bruesewitz against Wyeth, the case holding that the National Vaccine Injury Act preempts design defect claims under state law against vaccine manufacturers. I had the privilege of arguing it for Wyeth, and I think it was a great decision for public health as well as for Wyeth, because it helps prevent the kind of lawsuits that would lead vaccines, which are an unusual product, to be produced less and fewer children would be immunized, and that leads to contagious disease outbreaks. So I think this was a case in which, given an administrative compensation system in the federal system, there was a kind of a good argument for both camps on why there was preemption here. There was also the lap belt shoulder belt case, as distinct from the seat belt airbag case of 1984. You're going to help us understand the front seat, back seat distinction between Mazda and Geier. And then Pleva versus Mensing, a very interesting case that looks just like Wyeth against Levine, which held failure to warn claims against branded pharmaceutical manufacturers not preempted by federal pharmaceutical law. Along comes Pleva versus Mensing this term and says, well, failure to warn claims are preempted against generic manufacturers, so help us understand the pharma-generic distinction and help us put these cases into context.
I was hoping you would do that.
In 5 minutes.
These cases, like the class actions, are all about access to courts. And so more than they like state rights, and I think even more than various members of the court, like corporations, they don't like lawsuits, is my view. I don't think they like litigators. They don't like litigation. And so there's a lot of cases that are about keeping people out of court, and the preemption cases fall in that category. Bruesewitz is the easiest one, the vaccine case. There is an extremely poorly worded statute, and neither side's argument is entirely satisfying about what this particular clause means. So there's a lot of argument in long briefs and an hour of Supreme Court time about how to read this sentence, and the court has to pick, and it picked one. So
The right one.
The other two, so that's an express preemption case. The other 2 cases, Pleva versus Mensing and Williamson versus Mazda, are implied preemption cases, and there's 2 kinds of implied preemption. 2 kinds of implied conflict preemption: impossibility and obstacle. So we have one of each this term. Traditionally, state common law has provided a cause of action for manufacturers' failure to take reasonable steps to warn or to make its products safe. And when the product is subject to federal regulation, state law provides that, most every state, if not every state, provides that compliance with the federal requirements is evidence to be taken into account as to whether or not the manufacturer acted reasonably. But the question is whether a reasonable manufacturer would have gone above the federal regulation to provide more safety or a better warning. We've had about 20 years now or so where manufacturers have argued that that preemption provisions, or rather that federal regulation, isn't just a defense under state law, but it's actually a legal barrier under federal law to bringing the suit in the first place, regardless of the merits or the reasonableness of their conduct. So Williamson and Pleva are part of that development. Unfortunately, given the time, you can't understand Williamson without going back 10 years to Geyer versus American Honda Motor. In that case, which was 5-4, Justice Breyer, for the majority, holds that a claim that a car should have had an airbag at a time when the federal regulator said you can have an airbag, you don't have to have an airbag, and we're phasing in the requirement about having airbags or other passive restraints. That you couldn't sue about not having an airbag during that phase-in period, because as the 5 justices read the regulatory history, the agency thought it was very important that manufacturers have a choice during that time. So then we have about, excuse me, about 10 years where the manufacturers argue that any time a regulation gave a choice to manufacturers, there was preemption. Geyer was read very broadly, and although at the time it came out, I wrote an article about how it was actually pretty good for consumers, it turned out that it was pretty bad for consumers for most of the decade. Williamson was one of those cases where Geyer was used to argue preemption. The opinion in the case, which is very short and unanimous, it's fact-specific. You will have to look hard to find any grand legal pronouncements. It just sort of goes through the regulatory history, applies Geyer, and you might think it's not that important, but it's actually critically important in products liability cases, because in it the court says that most other courts and defendants have been incorrectly reading and applying Geyer, and that in fact you really do have to look at what the agency was trying to accomplish, that just because the agency gave choices doesn't mean that a manufacturer is protected when it makes a bad choice. So it turns out that although it doesn't really break any new ground, it's a pretty important decision just for telling people how to read the prior case.
Is it fair to say that the biggest difference between Geyer, which held preemption to apply, and Mazda, which held preemption not to apply, was the litigating position of the United States government? The Solicitor General urged preemption in Geyer and urged against preemption in Mazda, and that's particularly significant to Justice Breyer, the author of both.
Yes, absolutely, Justice Breyer would have ruled the other way had the Solicitor General come in on the other side. But it would have been hard, given the regulatory record, for the government to have said there was preemption, because there's really no basis for it in the Federal Register notices, which is what both decisions are really just quotes from the Federal Register notices. But the government's position is extremely important in all the preemption cases, and unless, as happened in Wyeth, the drug case from a couple years ago, unless the government's really overreaching, the court is extremely deferential to their position in preemption.
So tell us what happened in Mensing.
So in Mensing, the government actually lost. Wyeth is the name brand drug case. Can you sue a name brand drug manufacturer for injuries caused by the product that were not adequately, that they didn't adequately warn about on the label? And in Wyeth 6-3, the court held that the drug companies can be sued, that the regulatory system does not immunize them from liability. PLEVA is generic drug companies. They're making the same argument, or they're seeking the same result, but their argument is that under the Hatch-Waxman Act, which is the law that sets up the system for generics and was intended to encourage use of generics, that under that act, generics are required to use the same label as the name brand manufacturers, and so they simply could not provide a better warning. So although this particular product had quite a serious injury, and there's a lot of suits about it, they were just stuck, they said. There's nothing they could do to comply with state law. So this is analyzed as an impossibility case. And the FDA says, well, it's true they can't unilaterally change their label, but they can come to us and say, look, this bad stuff is happening. You need to let us change our label. In the beginning of the opinion, this is a 5-4 case, Justice Thomas, who hates obstacle preemption but apparently likes impossibility, he says, well, the FDA says this about how they can't change their labels. We'll the agency knows we'll defer to them on that. But then when the agency says, but they can come to us and ask, he says, well, I don't know if that's right or not, so we're not going to decide that. And he goes on to find that I think the dissent put it this way, not him, but that the possibility of impossibility was enough to create impossibility preemption. One odd thing about the opinion, he has a couple-page passage going off on the origins of the supremacy clause.
A non-obstante clause.
Yes. So we've learned.
Meaning that a federal law implies repeal of a contrary state law. And so in a way, there's a presumption in favor of preemption rather than a presumption against preemption, which is what the advocates of state lawsuits being not preempted said there was. So is the presumption against preemption dead now on the court? Stevens was its leading exponent. Justice Stevens was the leading exponent. Justice Stevens, champion of federal power in Commerce Clause cases, Civil Rights Enforcement Clause cases, state sovereign immunity cases. He railed against notions of states' rights in the Rehnquist Court federalism cases, and yet was the biggest champion of the freedom of states to deviate from federal agendas and to allow state common law causes of action to proceed, whether against cigarette manufacturers or auto manufacturers or other consumer product cases. And Justice Stevens said there's a presumption against preemption. And Justice Thomas, in effect, is saying there's a presumption in favor of preemption, but he only gets 4 votes.
Right, but he only gets 4 votes for that.
So where's the presumption?
Well,
Neither way?
it depends who writes the decision. I expect the presumption will be back, and then it will disappear again. I think that the presumption gets a lot more discussion in amicus briefs than it really warrants. I don't think it really makes a difference.
It's
in
just
the
added
cases.
on to an outcome, possibly. But just last point on this, the Obama administration announced at the beginning of office in the first term that there were important things the states were doing. It was a kind of blue states' rights plea, that there are a lot of important things that are good about states' freedom to deviate. If there's a regulatory vacuum at the federal level on greenhouse gases or predatory lending in national banks or approaches to consumer privacy, then there has to be some freedom for states to deviate. So is there a kind of blue states' rights movement now on the left, whereas the right has moved to nationalism, economic nationalism? A little bit?
I think it's about accountability and the ability of consumers to hold corporations accountable is more important on the left than on the right.
Okay.
And they're not really so concerned about states' rights, but about accountability.
So federalism isn't doing the work so much as a concern about who gets to decide about injuries and so forth. And so conservatives trust in the federal expertise of the federal agencies, whereas liberals are happy to have juries speak truth to power at the local level. That's how you see it?
Yeah, I do.
Okay, great. Lucas, you want to turn to the last of the preemption cases for the term, but it helps us move to your area of expertise, which is immigration.
Immigration.
Tell us about Chamber of Commerce against Whiting.
Well, so Chamber of Commerce versus Whiting is also a preemption case. It arose in the context of a challenge to an Arizona law regulating immigration, not the one that's gotten all the attention recently, the so-called SB 1070, but an earlier iteration of state and local regulation of immigration that's now reached the Supreme Court. That first arose in the Hazleton case, and then the state law in Arizona, where states are enacting laws purporting to regulate immigration employment by penalizing employers who hire undocumented workers under their own state scheme, and also mandating the use of the electronic so-called E-Verify system, which is an electronic database that the federal government has set up as a voluntary measure which employers can enroll in if they so choose. And what the state of Arizona did was set up its own regulatory scheme for penalizing employers by revoking their business licenses if they hire an undocumented worker as determined by state court adjudications, and requiring every employer in the state of Arizona to enroll in the E-Verify, making mandatory what the federal government made voluntary. So a coalition of civil rights organizations, labor unions, and the Chamber of Commerce sued the state of Arizona, arguing that this state law was preempted under the 1986 immigration law, which had an express preemption provision providing that all state and local laws regulating immigration employment are expressly preempted, but also having a parenthetical savings clause saying everything is preempted other than licensing or similar laws. So the question was whether the Arizona law constituted a licensing law within this very narrow, presumably narrow exception to an otherwise very broad express preemption provision. So it's interesting to contrast it with Concepcion, where they also were dealing with a savings clause and how the court looked at the savings clause in that case and in this case. Because in the Arizona case, the court upheld the Arizona law, saying notwithstanding this express preemption provision, we will read the savings clause within the preemption provision very broadly to authorize this state regulation. It was a 5-3 vote, one of the many cases in which Justice Kagan was recused because the Solicitor General had entered on the side as an amicus on the side of preemption, arguing that the federal statute should be read broadly to preempt. The savings provision should be read narrowly, not to allow this provision. In a 5-3 vote, the court upheld the provision on the grounds, looking really first and foremost at the dictionary definition of license and saying, well, license is something very broad. If this exception allows for a licensing exception, then Arizona says it's revoking business licenses. That's within the savings clause. And then on the E-Verify mandate, saying, well, the voluntary aspect of that was that the federal government could not make this mandatory, but that doesn't mean the states couldn't make mandatory just because the federal government could not mandate it. So in the face of all that, the court said that this is within what the states are permitted to do based on the very specific express preemption and savings clause in the 86 Act. There were dissents. There were separate dissents by Justice Breyer and by Justice Sotomayor, and they went off on slightly different grounds. And it's interesting because it relates to the Geyer issue as well and the relationship between express preemption and implied conflict preemption. Justice Breyer said that we need to read the licensing provision narrowly. We can't just look at dictionary definitions. We have to look at the purpose of the whole law. And one of the things that Congress was very concerned about when it enacted this preemption provision was to avoid discrimination, to have a very carefully balanced scheme, that there could be federal regulation in this realm, and that employers should be penalized, but they should also not discriminate. So we have penalty provisions against discrimination. We have penalty provisions against hiring undocumented workers. And if a state steps into this and imposes the so-called business death penalty by revoking a business license, that completely upsets the scheme, and we can't look at this parenthetical exception completely in isolation. And so he would have said that the law was not saved by the parenthetical exception. Justice Sotomayor went beyond that and said we have to, under Geyer, we look at not only express preemption, but also implied conflict preemption. And the mere fact that something fits within a savings clause doesn't mean that we don't also look at whether the state law is in conflict with federal law in its operation and so on. But they were in the minority.
How do you explain the court's rejection then, not only of the position of the U.S., but also of the business community through the chamber, that this ought to be preempted and it shouldn't be a state law decision?
Yeah, it's really, I mean, to me, having been involved in the case, inexplicable might be one, outcome-driven might be another. I think that there is a problem that the way the law was drafted did not reflect what the congressional concern was. And all of those who were involved back in '86 with the enactment of the statute would have never imagined, including some of the sponsors of the legislation who filed an amicus brief by Paul, that when Congress enacted this scheme, it wanted broad preemption. It had a narrow exception in mind that's clear from the legislative history, or relatively somewhat clear, I should say, from the legislative history, but it's not reflected in the text. So that, I think, is part of it. That there was a problem with this very broad term. And then I think there was some sympathy for the states talking and complaining about the problem of immigration. I will say that it's important to emphasize that the ruling in the case is very specific to the employment regulation issue that was presented in that case, One, because the court depended on this specific proviso in federal law authorizing licensing laws. And the opinion by Chief Justice Roberts also went into considerable detail explaining how there really was not a conflict between the federal adjudication and the state law because the state purported to rely on federal databases and federal determinations for deciding who's documented and who isn't. So he said, look, what's the big deal? It's just a piggyback scheme on top of the federal scheme, so there really is not a conflict here.
So what's going to happen in the big Arizona immigration case coming up?
Right. So I think the big Arizona immigration case, there's the state of Arizona has announced that it's filing a cert petition, which will be in by the end of July. And I think, it's hard to say. I think that case, it's completely different in terms of the legal issues, in terms of actual preemption. That's a case where there's criminal penalties, where law enforcement is allowed to engage in criminal arrests of allegedly undocumented persons, where it mandates police officers to detain people based on suspicion of immigration status. So it's not about employment. There's no proviso in federal law authorizing it. The only provision in federal law authorizes police officers with the specific authorization of the federal government. And again, it's a case where not only is the federal government an amicus, but it's the United States of America suing the state of Arizona that the SB 1070 interferes with federal law and with federal immigration priorities. We'll also, just one other little thing is that the court also, GVR, granted, vacated, and remanded the Hazelton decision where the Third Circuit had struck down a law like Arizona's law, the first iteration. The court sent that case back, which is a normal thing to do in light of the Whiting decision. And now the Third Circuit, I think, may be the first one to look at how broad or narrow the Whiting decision is and whether the very particular elements of the Arizona law were essential to preserving it under the court's interpretation of the Savings Clause.
So are we moving into a new era of state freedom to improvise on immigration controls to fill that so-called federal regulatory vacuum we talked about before?
I hope not, but there's certainly the states are enacting lots and lots of laws. There's been a lot of follow-up so-called SB 1070 copycat laws following this, not this Whiting case, but the criminal enforcement type laws. So far, every single one of those have been enjoined at the district court level on the grounds that they are preempted, that these are really getting directly into the regulation of immigration in ways that are completely impermissible, and they don't have a hook within the law to justify them, but we'll see.
Let's turn to the criminal procedure docket, and there are a lot of criminal cases this term. We can't cover them all. A few trends, a few more chips away at the exclusionary rule in the Fourth Amendment cases. And we'll talk later about some of the other cases, but I want Erica to focus, if she could, on the Confrontation Clause cases, the Sixth Amendment Confrontation Clause cases, where there's been a surprising trend with an unusual lineup toward originalist enforcement of the right to confront the witnesses against you, which has led to some big victories for criminal defendants in the Crawford line of cases through the Melendez-Diaz case last term. Is the trend on the Sixth Amendment continuing this term? Tell us about Bryant and Bullcoming.
It's interesting. I don't know whether it's going to continue as it's been. So the alliance between Justices Scalia and Thomas and the traditional left wing of the court, Justices Stevens, Souter, and Ginsburg, did lead to Crawford and the Crawford line of cases. Just for those who have forgotten about confrontation, in 2004, the court held that if documents or statements of witnesses were introduced, the defendant had the right to confront the declarant of those statements if the statement itself was testimonial. And Crawford was stated as a pretty absolutist rule. If there was no confrontation, then the statement could not come in. So if the declarant wasn't there to be cross-examined, the statement couldn't be admitted. And that continued fairly uncontroversially, I guess, although the court was really trying to figure out what the term testimonial meant. The court appeared to be pretty solid on the fact that testimonial statements would not come in absent the right of confrontation. The first break in that, I think, came in 2009 with Melendez-Diaz. And it appeared pretty clear that at least 4 members of the court, Justice Kennedy, Chief Justice Roberts, Justice Breyer, and Justice Alito, started to take a much more pragmatic view. And they looked at the value of confrontation for the particular document or whatever it was that was being introduced, and the cost of requiring confrontation. And if that balance was, was too expensive for the states, there seemed to be a trend by those 4 to have the confrontation clause not cover those statements. The other 5, though, at that point, it was Justices Scalia, Stevens, Thomas, Souter, and Ginsburg, were still solidly in the confrontation camp. If it was testimonial, it was not going to come in. 2 years later, here we are in 2011, and Justice Souter has been replaced by Justice Sotomayor and Justice Stevens by Justice Kagan, and we get 2 confrontation clause cases. Michigan versus Bryant and Bull Cumming versus New Mexico. I think what becomes clear in both of those is that Justice Sotomayor is emerging as the swing vote, and that she is much more in the kind of pragmatist camp than I think a lot of people had expected her to be. In Michigan versus Bryant, the issue was whether an excited utterance by a victim who had just been shot, the statement he gave to police officers, whether that statement is testimonial or not. And Justice Sotomayor, writing for the court, joined by Chief Justice Roberts and Justices Kennedy, Breyer, and Alito, the Melendez-Diaz dissenters, held that the statement was not testimonial. And a significant part of the opinion talked a lot about the reliability of this statement. We're not worried that this victim is going to lie because it's an excited utterance. He didn't have any reason to lie, so we don't really need confrontation. Or at least that was how Justice Scalia interpreted the language in the majority opinion. The Michigan versus Bryant opinion, bringing in, as it did, I think, a lot of those kind of pragmatic considerations, drew a very scathing dissent by Justice Scalia. It is one of the most strongly worded dissents I've seen in a while. And he took the very strong position, this is a testimonial statement by any definition. And once it's testimonial, the confrontation clause says, doesn't matter how expensive it is, doesn't matter how much the state wants to get that statement in, it cannot come in unless there's confrontation. And there couldn't be confrontation here because the victim was dead. The second case that came up, I should also say about Michigan versus Bryant, that Justice Kagan did not participate in that decision because she was recused. So it wasn't clear how she was going to come out in these confrontation clause cases. The second case to come up was Bull Cumming versus New Mexico, which involved the issue of whether if an expert report is introduced and the expert who prepared the report is not available for cross-examination and the state finds somebody else who works also in that same area to be cross-examined, does that satisfy the confrontation clause? Given the holding in Melendez-Diaz just 2 years earlier in a 5-4 decision, Bull Cumming should have been a very easy decision for the court. It ended up with a 5-4 decision, again with the same justices dissenting. Justice Kagan joined the majority opinion written by Justice Ginsburg saying Melendez-Diaz controls this case. Interestingly, Justice Sotomayor did not join one part of Justice Ginsburg's opinion and also wrote separately to say, I think this is a very, 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 very narrow holding and so won't be that costly to the states. It leaves open all of these other confrontation issues and we're expressing no view on any of those confrontation issues. Read the Bull Cumming decision very, very narrowly, I think. And then the Supreme Court promptly, Bull Cumming was just decided, and the court then almost immediately turned around and accepted cert on another Confrontation Clause case for next term that raises one of the issues that Justice Sotomayor had said was going to stay open. So in the Confrontation Clause area, I think Justice Sotomayor is really turning into the swing vote. And she looks much more pragmatic in her opinions than I think, certainly than I think Justice Souter had been, and then I think people had expected her to be.
Spent a lot of time as a state prosecutor. As
Yeah,
one of
she
her
did.
and
That's
so
right.
it may be a factor. All right, so Sixth Amendment may be going the pragmatic way of the Fourth and Fifth, not the kind of originalist bulwark it's been. Paul, let's go to the First Amendment. And it was a big term for free speech rights. The speakers won all the prominent free speech cases of the term. The case about violent video games struck down California's ban on the sale to minors of certain kinds of violent video games. Sorrell versus IMS, the case about pharmaceutical detailing, which held a First Amendment right to acquire and distribute certain information about physicians' prescribing habits against a Vermont law that purported to protect physicians' privacy. A case about the right to speak in campaigns, in political campaigns, being burdened by a rule that gives more money to your opponent from public finance if you speak above a certain amount with private dollars. The Arizona trilogy of cases that were combined there. And a case upholding the right of the Westboro Baptist Church proponents to attend military funerals, and so long as they were peacefully speaking on matters of public concern rather than targeted interpersonal insults, the right to speak and to the First Amendment limitations on the tort of intentional infliction of emotional distress in Snyder versus Phelps. Big trend toward freedom of speech. John Roberts has made a mark as Chief Justice, speaking out for a broad conception, libertarian conception of freedom of speech. How can you help us put the free speech cases this term into context? And of course, Paul, congratulations on your win in Brown versus EMS.
What I would say is what's really happened that's made free speech claims so strong in this court is the emergence of Justice Scalia as Justice Kennedy's partner in almost every case as the reliable, strong advocate of free speech rights. Sometimes they're allied with the more liberal members of the court, sometimes they're allied with more conservative members of the court, depending on the kind of speech claim it is. But when you have those two voting consistently, it's very difficult to lose 5 votes. And so, especially as you point out, Chief Justice Roberts is often there as well, although not nearly as reliably, I would say, as Scalia has become. Sorrell and Brown, 2 examples of this, one where the pair allied with the liberals and one where they allied with the more conservative members of the court. Brown, the video game case, there's a California statute that says you can't sell video games to minors if they allow the player to inflict violence on a human being. We learned at argument that does not include Mr. Spock because he was a Vulcan, but a human being. And if it meets the following definition, which they had taken from the obscenity law, which is to say it has to be appealing to a morbid or deviant interest in violence, it has to be patently offensive for minors, and it has to be lacking in redeeming artistic or social value. And so you can imagine we made 2 basic claims about this. One was the big claim, which is there's no First Amendment exception for violence. There is no obscenity exception for violence. This is a content-based law. It's subject to strict scrutiny, and strict scrutiny is nearly always fatal under the First Amendment. The narrower claim was, who the heck knows which games appeal to a morbid interest of a 17-year-old in violence and are lacking in artistic value. They give awards to these games for their artistic creativity, but other people think they're horrible. And so the law is utterly impossible to apply and was too vague. As it turned out, we got 5 votes in a very striking First Amendment opinion written by Justice Scalia for the big theory, which is he rejected all of the arguments for creating a new exception to the First Amendment for anything other than strict scrutiny that would apply. He said obscenity is obscenity, and 200 years we have not treated violence that way. He rejected the arguments that the interactivity of these games in some way creates a difference from other forms of expression, and expressly said they should be treated just like books, movies, and any other form of expression. And then, having decided that strict scrutiny applies, he went on to fairly aggressively decimate the social science that the California attorneys had put forward to try to justify this law, noting accurately that the same social scientists had testified that they found the same levels of effects and the same concerns raised by watching the violence in Roadrunner and Bugs Bunny and other Saturday morning cartoons. And so if the state had been consistent about really being concerned about this, they would have regulated virtually all video games. We got a mention of Sonic the Hedgehog, but also Saturday morning cartoons. And then he went on to say, you know, they say they're trying to help parents, but the reality is there is an existing rating system out there that is enforced by retailers 80-90% of the time. And so to some extent, this is a solution in search of a problem. Interestingly, Alito and Roberts concurred, even though they were very negative at the oral argument on a vagueness issue. They were quite critical of the broader protection that Scalia's opinion will accord to video games. And then Thomas and Breyer dissented. Thomas on the theory that if you're under 18, you have no First Amendment rights at all, unless your parents have agreed to let you have them. And Breyer, who is emerging, I think, is probably the weakest guy on the First Amendment most consistently on the court, essentially saying, well, you could call it strict scrutiny. You can call it what you want, but I think there's enough bad stuff here, and it's clear enough to me that these games ought to be regulated.
Well, one dissent was from the 17th century, and one was from the 22nd, right? Justice Thomas said, children have no free speech rights because our traditions going back to the 17th century say they're controlled by their parents.
Right.
Justice Breyer said there's a lot of social science evidence that will get into brains and show us that actually we are inured to violence. So they couldn't have been more opposite in method,
Right.
but both
I
dissent.
mean, the bottom line is you have a majority opinion of the Supreme Court which expressly rejects all those dissents and very vituperatively says the First Amendment's going to apply here. There's a lot of problems in society, and these games may be problems, but there are a lot of problems you can't solve through censorship of speech, like, for example, subversive speech and other things, and we're just not going to do this. So Scalia is quite a remarkable opinion. Now, in Sorrell, this is the commercial speech case where the conservative wing of the court got together, joined, as it happened by Justice Sotomayor, and 6-3 threw out a Vermont statute that was designed to kind of deter the practice of doctors prescribing too many brand name drugs and encourage them to prescribe more generic drugs. And Vermont's view was that the reason doctors are prescribing brand name drugs is they're too effectively marketed by the pharmaceutical companies. And that the way that happens is the pharmaceutical companies were buying indirectly from the pharmacies information about which drugs each physician tends to prefer to prescribe. They would use those data when they make personal visits called detailing to the offices of each of the doctors and say, well, I don't know why you keep prescribing this generic, Lipitor would be much better, and you would, lo and behold, Vermont says they would be prescribing more Lipitor. And so the law said it's illegal for the pharmacies to sell off this information for the purpose of promoting marketing of drugs, and it's illegal for pharmaceutical companies to use this information for the purpose of marketing drugs. And just one thing to note about that, patient information was not there. It was masked, or at least that was the way the case was understood at the time it went to the court. It was just, there was a privacy argument on behalf of the doctors, that the privacy about what they tend to prescribe, but the court rejected that on the theory that insurance companies know this, the state knows this, all sorts of other people know this. There's not really much privacy interest there. But the main defense of the law by Vermont was, we are attempting to change the marketplace of ideas because it's too persuasive. And the court decisively rejected that, applying the sort of core commercial speech doctrine that if something's legal to buy or to do, you should either regulate it or not, but you can't try to affect people's behavior by changing the information they get in commercial advertising. And so that was a very strong reaffirmation of that basic commercial speech principle. Justice Breyer wrote the dissent saying, I'm not sure this is all that big a deal, and I don't know why Vermont can't pursue this legitimate interest in this way. And if the doctors want to have this information, they can agree to have the information provided to the pharmaceutical companies. They can opt in if they want. So he didn't see this as a major First Amendment problem. But then his way of handling all these cases is, if it's a First Amendment claim, that triggers a kind of practical balancing of interests in which Justice Breyer decides what interests are important and which ones aren't, and tells you what he thinks. So
no special preference for First Amendment values.
It's certainly nothing that would suggest that you apply the rules in a way that might lead to an outcome that he thinks is unfortunate in terms of a societal outcome. So.
Justice Alito also shows no special reverence for the First Amendment in every case. He was the lone dissenter in Westboro Baptist Church, Snyder versus Phelps, and again, a few terms ago in U.S. versus Stevens, the animal fighting video case that said he is willing to see new areas of unprotected speech where social mores
Right.
are being protected.
On
So
the
it
other
was
hand,
quite
it's extremely
impressive.
strong
You got his vote.
adherent. Justice Lee is very strong on the First Amendment in other areas.
Yes, Doe
Religious
versus Reed.
speech in the Hastings Law School
Hastings
last
versus
term.
Martinez, and
Certainly
Doe versus
the-
Reed, the lone person who said you have a right not to be disclosed, your identity, a right not to disclose your identity as a petition signer.
The one guy who seems to be in dissent in almost every case, though, is turning out to be Breyer.
Yeah.
Not every case,
No
but certainly
special sympathy for the First Amendment.
Right.
Well, Chris and Suzette, let me get you going. On the question we opened with, was the term a pro-business term? Was the court too pro-business or not pro-business enough? Chris, you want to start us off?
Well, I would say that if you think the Roberts Court is very pro-business, there are some data points in this term that sharply go the other way. Mazda loses a very important case about preemption, a case where they were complying with federal law. Federal law gave them a choice between two options. They complied with it, but the Roberts Court says, well, that's still, you can pick one of those options and still be sued under state law for exercising that federal choice. The Chamber of Commerce loses in the immigration case. In the 3 securities fraud cases I discussed, two out of the 3 go against the public corporation that was the defendant. So, query whether analyzing if corporations win particular cases tells you very much about the court or whether that case was rightly decided, but certainly corporate America suffered its share of losses in this term.
And Suzette, what about in the employment discrimination area, apart from Walmart v. Dukes?
Yeah, I have often thought that you see a lot of pro-business cases coming out of this court when you think about procedural things like arbitration, class certification, pleadings. And so I think certainly I think that fits in that arena. But if you look at the employment discrimination retaliation claims, really the employees are winning. And so that's where that model doesn't quite fit. Certainly the last couple of years you see either unanimous or almost unanimous opinions coming out of the court where there is a robust protection for employees who complain about some kind of potentially unlawful conduct going on in the workforce. And this term was no exception to that. There were basically 2 cases, the Kasten case and the Thompson case, which kind of reiterated that protection for anti-retaliation type claims. In the Kasten case, this was the court had held, and it wasn't a unanimous opinion, but the court had held that under the Fair Labor Standards Act, under their anti-retaliation provision, that if you complained orally, that counted, and that was protected under the anti-retaliation claim. You didn't have to complain in writing. And so there you had a worker who was upset because the time clock was up on the wall, and the time clock was not in the proper position, so when he would have to put on his protective gear and take it off, that time wasn't being included, right?
Donning and duffing.
Donning and duffing. So he wasn't getting credit. He was supposed to be paid under the Fair Labor Standards Act for the time that he was donning and duffing. That wasn't happening. And he was making oral complaints to the supervisor and to the HR people that was illegal under the statute. And ultimately he was fired. And he said, he brought a claim saying, first of all, I didn't get paid the money I was supposed to get paid for donning and duffing. And second of all, I think you retaliated against me for making those oral complaints. And the court agreed that the oral complaint was covered under the anti-retaliation provision, that was filing a complaint, and that, in fact, counted.
Allison?
I have a question for you. It seems to me that the court has some sympathy for retaliation claims, but not really any sympathy for discrimination claims. Do you see it that way?
I think they make a difference. I do think they make a distinction between retaliation claims and some of the other Title VII sort of generic discrimination claims. And it's hard to know exactly why that is. It might be, it might be that there's this broad interpretation of retaliation claims because the retaliation statutes they're either very clear or they're on the face of the statute, the text itself gives the court the opportunity to interpret that statute broadly. And to the extent that conservatives are sort of following the text, right, and using that as the basis for making determinations, then that makes sense where you have some wiggle room is where I think you start to see that divide. So I do think that there is
It's
a
an interesting
distinction.
counter to your theory that
Yeah.
they don't like litigation because a retaliation claim encourages litigation
Well,
and
that-
complaints.
It does, and I would say that with retaliation claims, what I think employers don't like about these retaliation claims is that it increases litigation. In fact, at this point, retaliation claims make up more than 1/3 of all of the charges that are filed with the EEOC. And last year, retaliation claims exceeded race claims for the very first time for those claims that are brought with the EEOC. So there is, in fact, I think, more claims coming up because of that very, I think, very robust protection for retaliation claims.
You know, what you said does fit in with my other theory, which is that plaintiffs win, and usually not in really close cases, by really close votes, when what the court is presented with seems like a narrow textual argument. For instance, Chris said that Halliburton was a very narrow decision, plaintiffs won. And I think Williamson was seen by the court as a narrow, let's look very specifically at these Federal Register notices sort of decision, the plaintiffs win. So they can win these textual things. The court's comfortable with that.
Right.
Give them some wiggle room. And
Then then you start seeing differences.
And I would add, I mean, I think the reason why you see retaliation emerging is something the courts have favored, is in part because they're individual cases and that people have real stories to tell. The conservative members of the court are much less skeptical that this is really a lawyer-driven, big cash-in kind of class action thing. And that's what they're most suspicious of, is the plaintiff's bar. And so you see these very aggressive moves against class actions in the employment discrimination area. A long history, record now of cutting back on potential defendants in the securities area, and of course the pleadings and other procedural aspects of it. But I think, you know, there is a majority of the court that thinks that the plaintiff's bar is ginning up big cases that don't really have a lot of merit or that the defendants shouldn't have to deal with.
So contingency fee, product liability cases and class actions may lose, whereas individual claims like the fiance, the guy who's allowed to complain when his fiance is fired. Right, so,
right.
And maybe so. I want to be sure we leave some time for audience questions, but we've left a couple of big cases on the table for the term, and I want to come back to them. Erica, could you just tell us a little bit about prison overcrowding? And just to preface this was a 5-4 decision, and it led to a very sharply worded disagreement on the court. California was charged with 8th Amendment violations for triple stacking men in prisons. To see the picture is to see how crowded those prisons were. And yet to order relief for this, in Justice Alito's words, was to unleash 3 squadrons of men onto the unsuspecting California populace if you release prisoners. Justice Scalia, channeling his inner Keith Olbermann, said that the 5-4 decision written by Justice Kennedy was the worst injunction in the world. So tell us about Plata versus Brown.
Hard to follow that description. It was a 5-4 decision authored by Justice Kennedy. And I think there are a couple of interesting things about it. One is that it gets described a lot as just a prison overcrowding case. And I think part of what generated the dissents is that the 2 class actions that were at issue here, one was a class action brought on behalf of inmates with serious medical conditions, and the other was a class of prisoners with serious mental health conditions. And so the state had essentially, in one of the cases, had conceded liability and had consented to some sort of a remedy. I mean, these were really bad. These prisoners were being treated very, very badly. And one of the contributing factors was prison overcrowding. California was not able to hire enough doctors. According to the majority opinion, they were hiring anybody with a medical license, and they still couldn't fill all of the positions that they needed to fill, and so they couldn't care for all of these inmates. So overcrowding was definitely one of the problems. The California court convened a 3-judge court and ordered as the remedy that California had to bring their prison populations to 137.5% of capacity. So they gave them way over 100% capacity. But California appealed, saying, look, we can't bring this down in time, and therefore we're going to have to release people, and the people that we're going to end up releasing are not the members of the class, but instead, and you can get Justice Scalia's description of who's going to end up getting released, the people who have been spending time in the prison gym, right? And so it was an interesting opinion for class actions, I think, given the court's seeming hostility to at least some class actions. I think the opinion came as somewhat of a surprise to many people. Justice Kennedy joined with the more liberal members of the court, and it was a pretty strong opinion saying, look, when things are this bad, you've got to have a remedy. And the three-judge court was pretty specific in all of their factual findings, and I think did a pretty good job preserving that record. That, of course, did not stop two very strongly written dissents. Justice Scalia, and writing for himself and for Justice Thomas, seemed to want to relitigate whether this should be a class action in the first place, which was not part of anybody's arguments, but he did have an entire section of his opinion saying, I don't understand why this is a class action and why there's a class action remedy here. And then Chief Justice Roberts and Justice Alito wrote separately to say that under the Prison Litigation Reform Act, they thought this remedy was not warranted. But so I think it was somewhat of a surprise, particularly given what happened in a lot of the other class actions. And I think part of it was kind of the visceral appeal of, Justice Kennedy included in his opinion pictures of where these prisoners were being held when they couldn't get medical care, and they were held in these little things that looked like old phone booths used to look, and they were locked in there. Prisoners with serious mental illnesses were locked in there, and I think that really affected Justice Kennedy and may well have led to his vote.
And it was a little bit of the dignitary Justice Kennedy, the shades of the Justice Kennedy we saw in Paul's magnificent win in Lawrence versus Texas, or in Romer, where he talks about aspects of human personality that should be protected by constitutional rights.
That's exactly right, I think.
So turning just to two last cases, then we'll open it up. Paul on American Electric Power, and then we'll go to Lucas on Al-Kid.
Quickly, this was a case in which states and some nonprofits sued the 5 largest utilities in the country, claiming they were causing global warming. They sued them under federal common law using the standing that had been arguably won in Massachusetts versus EPA to say, let's begin cutting back on global warming by going after the largest emitters of greenhouse gases. The Second Circuit got everybody's attention when they suggested this was actually a potentially meritorious claim and you ought to go to trial. Once cert was granted, I think it was only a matter of which way the utilities were going to win. The arguments that were made pointed out that there are literally billions of sources of greenhouse gases in the world, and it's a little hard to blame 5 companies for their relatively minute portion of this. There were arguments about political questions. There were arguments about standing, given how small the effect would be if you even shut down these utilities in terms of the overall world supply of greenhouse gases. In the end, the court ruled on the doctrine of displacement, which is the doctrine that says federal common law gives way if there's activity going on in the legislative and regulatory realm. Even though the EPA doesn't actually have limitations on greenhouse gases in place, it was enough that they'd been held that they had authority to do so and were doing rulemaking in this area. How's that for a quick summary?
Excellent. Al-Kid, Ashcroft against Al-Kid.
I can match that.
And
So-
That'll be a
where are
little
we
harder.
on? And where are we on the war on terror
Right.
this term?
The war continues, and the litigation is wobbly. So Al-Kid was a damages action under the Fourth Amendment against the Attorney General for the alleged policy that he had adopted to misuse the so-called material witness statute, which authorizes the detention of someone for purposes of that person appearing as a witness in a criminal proceeding if other methods of ensuring appearance are not practicable. And the allegation was that the Attorney General, as part of the war on terror, had intentionally adopted a policy of detaining people under the material witness statute when they were actually suspected of crimes, but when there was not probable cause to arrest them for the crime. So it was a misuse of designating people as witnesses in order to detain them based on actual suspicion of criminal misconduct that wasn't sufficient to charge them with anything. And Al-Kid, who's actually a United States citizen, was detained and then filed lawsuit against both the individuals who sought the material witness warrant and against the Attorney General for developing the policy. And the Ninth Circuit upheld that against a qualified immunity assertion by the Attorney General. And kind of like the environment, once the Supreme Court granted cert, it was pretty clear they were going to reverse the Ninth Circuit. And the question is what they were going to do. And on the question of whether or not the misuse, the alleged misuse of the material witness statute in his detention was a clearly established violation of the Fourth Amendment, the court was 8-0 that satisfied qualified immunity and that Ashcroft could not be sued. So on that narrow question, there was unanimity. But more interestingly, on the question of whether the material witness statute was a constitutional statute, whether if based on what actually happened to Al-Kid, it was a valid warrant, and so on. There was a much more splintered court, and Justice Kennedy raised doubts about, at least preserved the question of whether the statute was constitutional against a straight-up challenge, whether you could actually use detention in this way for purposes of material witness. Justices Ginsburg and Breyer and Sotomayor reserved the question about whether this particular warrant was invalid, but on the question of qualified immunity, there was unanimity. But I think it was a warning shot across the bow that the policy itself, if it were directly presented outside the context of a qualified immunity statute, was one that the court was interested in looking at.
Yeah, but interesting, in the war and terror cases, the Guantanamo cases put constraints on the executive branch, but no individual, not Iqbal, not Al-Kid, and not the humanitarian law project have been able to succeed in war and terror-based claims, and the state secret privilege has kept a lot of other cases from going up. So yeah, no major individual victories against executive improvisation in the wake of 9/11. All right, it's time to open it up to the audience, and as we are at the National Press Club, I would like to offer the press the first opportunity for questions. Members of the press? Adam?
Paul, what took so long on the violent video games case? And what do you think of the theory that the Scalia opinion was quite terse, the Alito opinion fairly substantial? Is that consistent with the view that the chief assigned it to Alito in the hopes that it would go off on vagueness?
Well, now that you've answered your own question, Adam, that is my theory, that basically Roberts and Alito decided to vote our way, even though I think in their hearts they might have voted against us, to keep it narrow and write just on vagueness and actually suggest maybe ways that you could go about regulating these materials. And Justice Scalia at some point led the insurgency to get 5 votes to take over the case and write the much broader strict scrutiny opinion. That would seem like the most logical explanation.
It wasn't that Breyer needed time to write the 22-page appendix with all the social science?
He had the Supreme Court library do all that work.
There we go. It's an excellent library. Any other questions from the ladies and gentlemen of the Fourth Estate? If not, then let's open it up to the audience. Questions? Oh, okay, I'm going to have to call on someone. Yes, wait until the mic is handed to you. And if you would kindly stand and just say who you are. That was Adam Liptak of the New York Times, who needs no introduction.
I'm Chris Van Horn. And any insider predictions on the upcoming police use of GPS cases?
Great question. Who wants to take that? Erica?
No predictions. It'll be really, really interesting. I would be very surprised if the court ends up holding that it is a Fourth Amendment violation. But I've been surprised by this court before. And it is, there is that sense in which, so this is the case the court just accepted cert on with warrantless placing of a GPS device on a car and all sorts of evidence gathered as a result. It'll be interesting to see what happens. There is a sense in which I can see at least some members, some of the more conservative members of the court saying, you're coming in, you're taking people's private property, you're putting things on there, and you're following them around. But I would be surprised if that's what happened.
Any other views on the panel? Anyone think it's going to go in favor of the right? No idea. Maybe, Paul?
I mean, I think you could see a way that Justice Scalia, the guy who said that infrared, devices looking at people's
search.
homes is a search that would say a device planted physically on your car, but that gathers a monumental amount of data about the way you lead your life, even if all of it technically occurs in public, in some sense, would find that abhorrent. I hope so, anyway.
So
And I think it's interesting that the court added that question for cert, the placing of the device itself onto the car.
yeah.
But do you agree that if they allow it, they would then let it be sold to data mining companies so that advertisers and stuff could see on their site?
Of course. All right, great. Other questions up front here? Can we get a microphone?
In Westboro Baptist versus Snyder.
Hold on one second. Could you stand and say who you are and talk into the microphone? Thank you.
Sure, I'm Kelly Cotter. I work for a nonprofit. In the Westboro Baptist versus Snyder case, when Margie Phelps made the argument, I believe she's not a part of a law firm, or at least one with a Supreme Court practice. How often does that happen where an attorney like her makes arguments before the Supreme Court?
Very unusual. Was anyone there? Adam, you were there? I was there. It's unusual, right? Yes. She did very well in the Q&A, just reading the cold transcript.
It used to happen quite a bit more often than it does now. There's been an increasing percentage of cases argued by repeat players, which those of us who are repeat players think it's a good thing. But she did apparently do quite a spectacular job. I read the transcript, and she was really spot on in her argument. And every year you still have a few people who are doing their rookie argument from some small town law firm, including her opponent in that case, who was from York, Pennsylvania, and it's a very small firm.
Well, there's a big debate over whether the professionalization of the Supreme Court bar and the rise of the Supreme Court clinics and their leaders has displaced an old tradition of people arguing their first and only case in the Supreme Court. Public officials used to do it all the time. The state attorneys general used to show up to argue cases quite frequently without delegating the case to somebody. So it was maybe a throwback to an older tradition. Any other questions? Yes, let's see, take the second row here. Can we get a microphone here in the second row?
Hi there, Alyssa O'Connor. The Sixth Circuit ruled yesterday on the healthcare law, and I was just wondering, first of all, when you think that the case will, or the debate itself will get to the court, and then once it's there, any predictions you mitt have.
Great, who wants to take that? Paul?
I'm sorry to keep dominating the answering, but I think it's quite significant that the Sixth Circuit, with the two more conservative judges, ruled that way. One of them didn't, obviously, but Jeff Sutton is a very strong leader of the more conservative half of the federal judiciary, and a very respected fellow. And he wrote an endorsement of the constitutionality, if not the policy merits of the individual mandate. And I think that will potentially have a very significant effect on the way this whole case, these series of cases goes. But I think most people would predict the case will get to the Supreme Court this term, that there will be a cert petition filed by somebody in this summer, and it'll get heard this term and decided this term.
Even without a ripe conflict?
No, probably. I mean, I can imagine a situation where if the government keeps winning, they just don't take one. But
And there's been argument in 2 other cases, so we
Right.
could have a
Right.
conflict soon.
In time for a fall grant. Anyone disagree? Anyone think that actually there's a good chance for the challengers? Not so much? All right, next question. Yes, let's take one in the back. Yes, the gentleman right there, you. Yes, thanks.
Hi, Michael Vasquez. We just heard on Monday that the court granted cert in the FCC v. Fox Studios indecency case, and I was wondering if anyone would like to comment on how the Chief Justice's views on the First Amendment might affect that decision next term.
Does anyone want to respond without expletives? I thought it was awesome. Paul?
I mean, it was clear they were going to take the case. It was a federal, regulatory approach that had been held unconstitutional by the Second Circuit.
Yeah.
So it's hard to read anything into the cert grant. There have been a lot of justices in recent years who have said they think the idea that treating broadcast stations worse than cable stations in this day and age, when nobody even knows which is which, makes no sense as a constitutional matter.
And many people who think Pacifica is obsolete in
Right.
treating media as assaultive and coming at you without your ability to control them in a world where almost everything is subject to personal control. And technology was a big theme in the cases this term. A lot of times the justices would say we can't decide something because technology is changing. This may be an area where technological change actually drives a constitutional constitutional ruling. Should we get one more from the second row here? And you tell me, do we have time for two more? Two more, okay.
Hi, I'm Joshua Matz with Public Citizen, actually. I guess I'm curious to ask whether you see any interesting sort of new progressive ideas coming out of the court. I mean, so now there are two recently appointed justices. One of the criticisms that have been leveled, I'm in the ACS at my law school, FedSoc constantly points out, you know, they have originalism, they have textualism, they have these big ideas, ACS and progressivism, not always as obviously so. I'm kind of curious, do you think that either the justices on the court or lower court judges are putting forth specific ideas in areas of law or doctrine that have the potential to move the law in an interesting progressive direction?
It's a very interesting question. Who wants to take it? Chris?
Well, I'll comment that I think in his career, Justice Breyer has carved out a form of pragmatism that we haven't seen on this court, and that it's an approach that does lend itself and often results in progressive outcomes. So I think that's something new under the sun.
And do you think it's philosophically coherent in the way that originalism is as well?
Well, I haven't read his book, but he wrote a whole book saying it's coherent, so there's at least an argument for its coherence.
Any other candidates for new liberal or progressive contributions to jurisprudence?
We haven't heard anything much from Justice Kagan yet. I mean, other than the dissent she wrote in the Arizona campaign finance case.
And it was interesting. It was brisk. It had brio. It had a lot of style. Yes. It had a lot of animation. It wasn't bitter or combative.
No.
So
and
interesting.
you know, she was out of what, 50 cases or something this year.
26.
Yeah, it seemed like 50. So I mean, she has a long way to go in terms of evolving as a justice, and she may well be the person who could.
So we shall see. And we'll give the last question to the. I'm sorry. We'll take two questions. Let's get them both, and then we'll try to answer them together. The gentleman here, and then we'll take the woman on the end.
Lawrence.
Can you stand?
Yep.
Oh, I'm sorry. It's Mr. Hurley.
Lawrence Hurley from Greenwire. Since we got on to talking about grants, I wanted to ask about the wetlands case that was granted on Tuesday. I thought it was interesting because Kathleen, you had the GE case.
Robbed.
They didn't take, which was also a due process question to do with the EPA sort of pre-enforcement issues, and I was wondering what your thoughts were on, you know, the difference between those two cases and why they took one and not the other.
It's a very good question. The question is about whether there can be a due process objection to government unilateral procedures in the environmental law area. The GE filed a petition objecting to unilateral administrative orders. This is a challenge to an EPA order under a different statute, so there's a different statute. It's out of the Ninth Circuit, and I think there may have been more sympathy for individual defendants than a major corporate claimant in the area of overturning Ex parte Young. I thought they were so close that it was, frankly, it was disappointing that they didn't take them together, because I think the issue of unilateral, unreviewable administrative action in the environmental area is a very important issue that affects a lot of people, and I'm glad they took one of the cases. I'm sorry they didn't take both. And last question down at the end there.
Hi, Elaine Middleman, attorney. According to the New York Times, it seems that Bernie Madoff and Judge Chin have a slightly different opinion about white-collar sentencing, and I just wondered if the panelists thought that there should be a better explanation by judges as to what the grounds they end up with 150-year sentences or 3 lifetime sentences or something for white-collar criminals.
Erica, you want to take the last word on sentencing, and we'll wrap it up?
Yeah, so I'm not sure this is something that the court is going to become involved in. The most likely thing that I think we're going to see with sentencing is some more of these Blakely Booker issues. But I just don't see this court going down the Eighth Amendment route and saying that sentences are too long. I think these battles are going to end up being won much more by defendants in state courts and in state legislatures and maybe in Congress, because prisons are just getting too expensive. And I think that's where you're getting more defendants released than from the courts.
Ladies and gentlemen, you'll have more opportunity to talk to the panel at happy hour at the Laughing Man Tavern right after the panel, 1306 G Street. Thank you to the American Constitution Society and this panel for the wonderful discussion.